All right, good evening and welcome to Conservatism on Tap. I'm your host, Wes, and I am thrilled to be with you tonight. I hope you are having a great Father's Day. I know for me it's been a good one. My wife and kids got me some caramel turtle whiskey, so that is my favorite stuff. So I'm going to be enjoying that tonight. So what did you get for your dad, or how do you celebrate Father's Day? Leave me a note in the comments. I'd love to hear that. Do you take some time to think about your dad? Do you get a chance to call him? Or if you are a dad, what did you get today? I'd love to hear about that. But for our session tonight, what I really want to do is take a few minutes and look at what's happened this week. It's been a wild week. There's been a whole lot going on, a lot of great discussions within the conservative movement, and nothing bigger than what has happened on the Supreme Court. So we had a pretty epic decision that happened, and I want to go ahead and bring up an image of that and some of the information, and we're going to walk through that tonight. And I know probably everyone has someone who's been affected by this decision, personal relationships in your life, or maybe it affects you. I want to kind of set that aside, at least for a little while, and even try to hold back my own personal opinions about this and look at this as objectively as possible. So if you've got thoughts on it, let me know. But I want to go through the details of this case that was decided this week by the Supreme Court, and then look at some of the different justices and what they thought of it, especially when you have different appointees by Donald Trump, conservative justices, many thought, going at different opinions on this, having different arguments back and forth. We're going to look at that. But first, let's look at the details, because I think it'll help if people kind of understand why this case was decided the way it was and what it means, because there's so many social conservatives in particular who are reacting to this case, and I want you to know why. So we're going to look at the details here, and you see on this image Bostock versus Clayton County, Georgia. And essentially what happened in this case is you had three different individuals who were let go from their employer for either being homosexual, which was two cases, or transgender, which was a third. And in every case, they sued their employer, and it made it up to the Supreme Court. And essentially what happened is that they were trying to utilize what's called Title VII of the Civil Rights Act, and I've got a quote for it there, that talks about it being unlawful for an employer to fail or refuse to hire or to discharge any individual or otherwise to discriminate against an individual because of such individual's race, color, religion, sex, or national origin. So this was a law that was put in place obviously many decades ago and is now being brought back up in the context of homosexuality and transgender. And really it's that word sex that people are keying on. What does that mean, and how does that play into this case? And so the ultimate decision that was given in this case was from Gorsuch, one of the justices, and he said that an employer who fires an individual merely for being gay or transgender violates Title VII of the Civil Rights Act. So that was ultimately the decision, and we're going to work our way up to it. So when you look at the different decisions, I had a chance to read through the entire decision, including the people who were against Gorsuch. What you see is that every single side of the Supreme Court on this case agrees that the term sex in 1964 referred to the biological differences between male and female, that it didn't refer to someone being homosexual or to someone being transgender. But Gorsuch, however, one of the Trump appointees, held that biological sex and sexual orientation are irrevocably linked, that you can't separate them. And Alito, another one of the conservative justices who's been there for a while, held that biological sex and sexual orientation are not linked in the way that Gorsuch said. And then Kavanaugh, Trump's most recent appointee, held that it is not the Supreme Court's role to decide. And so now we're going to look at these different justices, because this is what I want you to see, is you have the different conservative members of the court. Three of these guys, three out of the seemingly five conservative justices, and they all have a different opinion on this case. So we're going to look at Gorsuch first. And I quoted him here. He's got a long opinion. And essentially what he says is that when an employer fires an employee for being homosexual or transgender, it necessarily discriminates against them on the basis of sex. And so he has an argument for this that's pretty unique. Essentially what he says, that if changing an employee's sex or gender yields a different choice by the employer, then it's a violation of Title VII. And his example is that if you had taken any one of these people who got fired in this case, and you had changed their biological gender, then they wouldn't have been fired. So if you took a man and then he's attracted to another man, And if you flipped his gender to female, therefore, he is being discriminated on the basis of his biological gender. And so for him, for Gorsuch, in his opinion, homosexuality is an individual's biological gender plus the gender or the sex to which they are attracted. That's how he looks at it. And transgender would be an individual's biological sex plus the sex to which they identify. And so that's why he's saying if you flip it, then you've got a different outcome. And so if changing an employee's sex yields a different choice by the employer, a violation of Title VII has occurred. Therefore, what Gorsuch is saying is that Title VII of the Civil Rights Act plays in ways that no one had really anticipated. That's his argument that led him to side against the other conservative justices. Now let's look at their response, because he issues this opinion and he speaks for the majority, but then Alito and Kavanaugh dissent for different reasons. So Alito says that neither sexual orientation nor gender identity appear on Title VII's list. Well, let's go back and look at it, right? So you see here in this middle bullet what Title VII makes unlawful for an employer to do, right? And you see on the basis of race, color, religion, sex, or national origin. So you don't see sexual orientation as part of this. And so what Alito says is that for the past 45 years, Congress has introduced bills, as recently as this year actually, to add sexual orientation to Title VII's list, but none has passed both the House and Senate. So this is very true. So you had bills passed in the House, but never ratified by the Senate nor signed by Donald Trump or any other president that would add sexual orientation separately to the list of Title VII and essentially update it for people who believe that it should be there. And so because Title VII prohibits discrimination because of sex itself, not everything is related to, based on, or defined with reference to biological sex. So what this means is Alito is essentially saying that whether you flip a person's gender or not doesn't really matter. What he's talking about is the homosexual act or the act of changing genders. And so Alito shows pretty conclusively that you could discriminate on this basis alone. For example, if you had a business and you said that you were going to discriminate on the basis of a person's attraction to something, then you could discriminate against both males and females, and it would not be on the basis of gender. And he shows that in his decision. So we'll look further. He says an employer could discriminate against all homosexuals or transgender people without regard to their biological gender. And so what essentially Alito is saying is that it's only if you look at a specific individual do you have to take in their biological gender or sex into account in order to get to the result that Gorsuch wants. And then you look at Kavanaugh. And what Kavanaugh says is that regardless of this debate between Gorsuch and Alito, doesn't matter whether it's written in or implied. He says our role is not to make or amend the law as written. Title VII does not prohibit employee discrimination because of sexual orientation. As commonly understood, sexual orientation or discrimination is distinct from and not a form of sexual discrimination. Congress has never defined sexual discrimination to encompass sexual orientation. It was Congress's role, not the courts, to amend Title VII. And instead, the court has unilaterally rewritten American vocabulary and law. And that's kind of what the point that I want to focus on tonight with you guys is when we look at the decision that came out of Bostock versus Clayton County, what you see is three different justices with three different takes. In the case of Gorsuch, you have someone who is essentially reading in something that has never been part of the law. And he's essentially saying, hey, we know that no one really believed this whenever they were writing the law. They didn't intend to add this to it. We know that since then, people have not tried to include it on the basis of this language. But today, we're going to start doing that. And then you see Alito saying, well, your logic doesn't hold up. And then you see Kavanaugh saying, well, hold on a minute. Regardless of whether the logic holds up, why are we changing things that Congress has the power to change? Shouldn't it be on them if we're going to make these sweeping changes that have not been previously considered? And so that therein lies sort of the anger, the conservative backlash against Gorsuch is who would have thought that given him being a Trump appointee, that he would go down this road of adding something to the law that was not there before. Gorsuch believes in a type of jurisprudence or legal theory called textualism, in which you take the ordinary meaning of the legal text or the term, you ignore the intention of the law, and You ignore the problem that it was trying to face, and you even ignore what's just or unjust in your own mind, or in terms of, say, the American founders. And you look at instead, what does this actually mean, and what are its implications? And he works through all those implications to get to this weird spot. And I think that's what's interesting is regardless of how you feel about the issue, whether you support the outcome or you have a discussion about this issue, about transgender and homosexual behavior, and what does that mean for our country? Because I think that most people, certainly the people that we've had on our page, on our channel, the people that we've gotten a chance to interview, that we interact with, are open to a sort of compromise. Because what comes up in the minds of many conservatives is religious liberty. And how is this going to affect a church or a charity that's religiously based? Are they going to have to change how they operate on the basis of this law? And maybe there's room for compromise, but that doesn't happen in Gorsuch's decision. He doesn't allow a lot of room for religious liberty to take place, and instead he's reading this in. And so the implications of this decision are absolutely sweeping, not only in terms of how are we going to relate to different people based upon their sexual orientation or needs, but also in terms of legal theory. Because now, based on Gorsuch and his approach to law, you could essentially read in almost anything that you wanted to into discussions of jurisprudence based upon what you want to see today. Going back to, I'll bring it up one more time, going back to the language of Title VII of the Civil Rights Act, no one is disputing what this law was designed to do. No one is disputing that that plain language had a specific meaning. Gorsuch is just simply saying an implication of this that everyone apparently has missed, including Democrats and Republicans all the way up until now, is being discovered by Gorsuch, and he gets to read that in. And that is just absolutely amazing. And so I've been following all kinds of conservative channels this week as we react to this and sort out what it means in terms of the future of the Supreme Court. But for me, it definitely brings into question the type of justices are getting put on. I tend to agree more with Kavanaugh on this if we look at his approach, because he is talking about we don't necessarily disagree with what happened as a result of this. It's simply the means of how we got there. It is not the Supreme Court's role to decide and read this in. If we got to a point where Congress decided this and we were able to work out all the differences in terms of how religious institutions are going to be affected, how we ensure that these protections happen for people of a particular sexual orientation, that's fine. That's what Congress is supposed to be doing. If we do it that way, then this could be a very positive thing for our country. Unilaterally reading this in without any type of consideration for the past, without any consideration for how it's been interpreted over the years up until this decision, is absolutely against the conservative approach to jurisprudence. So that's really what I wanted to talk to you guys about today. What are your thoughts on this? How do you see the Supreme Court in its decision making? Do you agree with one of these particular justices more than the others? Do you disagree with all of them? Let me know your thoughts. I'd love to hear that as we go through this week. I hope you've had a great Father's Day, a good weekend, and I'll be looking forward to seeing you next week.